So, imagine you're applying for a bank loan. You got the salary, the credit score, but you get denied. And it turns out it's because a weather app you downloaded like 3 years ago sold your location history.
Oh, wow. Yeah, probably to a data broker who, flagged you as high risk just based on the neighborhoods you visit.
Right. And the Philippines, I mean, that isn't just some tech glitch. It's actually a direct violation of the Data Privacy Act of 2012.
Yeah.
Or RA 10173.
Mm-hmm.
So today, our exploration into the source material is really about how this law takes you from being just a passive user to a protected data subject.
It's a massive shift in power, honestly. I mean, usually we feel completely at the mercy of big tech, right? But this framework establishes very clear roles. First, there's the Personal Information Controller, or PIC.
I like to think of them as, well, like a high-stakes valet. You hand them your keys, which is your data, so they can park the car and give you a service, but they don't own the car.
No, they definitely don't. And they are legally accountable for where they drive it or, who they let into the passenger seat.
And if that valet decides to take your car for a joyride, there's a watchdog waiting right at the end of the driveway, the National Privacy Commission, or NPC.
Exactly. They aren't just there for decoration. They monitor compliance and can actually shut down operations if a company refuses to play by the rules. To keep their license, so to speak, these valets have to follow 3 pillars of processing.
Okay, so what are the pillars?
It's transparency, legitimate purpose, and proportionality. Transparency means they can't just hide what they're doing in 50 pages of legalese. Purpose means the reason for taking your data has to be legal and specific.
But proportionality is the one that really protects you day to day, right? Like if I'm checking to see if it's going to rain, why does that weather app need my marital status or my SSS number?
Yes, that is knocking over the proportionality pillar right there. It's the need-to-know basis. If the data isn't strictly necessary for the service, they shouldn't be asking for it. This actually leads right into what we call your digital Bill of Rights.
I mean, I see that violated constantly. So how does this Bill of Rights empower us?
Well, it starts with empowerment through access. You have the legal right to know exactly what's being processed, and if it's wrong, you use your right to rectification. They literally have to fix inaccuracies.
Okay, but there's also the right to data portability.
Yeah.
Which, sounds like a technicality, but isn't the underlying insight here really about breaking monopolies?
Precisely. It's designed to prevent platform lock-in. You have the right to get your data in a format you can actually use elsewhere. It means you aren't stuck with the service just because they're holding your digital history hostage.
So you can take your car and go to a different valet. But what about the right to erasure? Like, I've tried hitting delete on apps before, and it feels like they just deactivate my account while keeping everything on their servers.
Yeah, that happens a lot. But this law actually forces them to wipe the drive. If the data was taken unlawfully or the original purpose is just over, you can demand it be blocked or erased from their filing system.
Wait, really? And what if they mess up? Like if they lose your data or sell it without permission?
Then you have the right to indemnity. You can actually be compensated for damages caused by unauthorized or false use of your data. It turns your privacy from this vague setting into a protected financial asset. It's about digital agency and ownership.
That is huge. Now, we have to talk about the stakes, specifically with sensitive personal information.
Oh, absolutely. The law treats things like your health records, race, and government IDs like tax returns with extra care. There are much stricter rules, especially for government employees handling this stuff.
And there's this 72-hour rule, right? Like a mandatory breach notification window. But let's be real. Is 72 hours even a realistic window for a massive corporation with millions of users? It sounds like a law that looks good on paper, but is impossible to follow.
It's tough, yeah, but it's intentionally aggressive. The 72-hour rule forces companies to have a response plan in place before the disaster actually happens.
I see.
Yeah, they have to notify the NTC, and the moment they have a reasonable basis to believe a breach occurred. Because the faster you know your SSS number is out there, the faster you can freeze your credit.
Right, that makes total sense. And the cost of negligence is wild. We're talking up to 6 years in prison and fines reaching 5 million pesos.
And here's the kicker. If a breach affects at least 100 people, it's legally classified as a large-scale violation. In our digital world, 100 people is nothing.
Wow. A single leaked spreadsheet at a small office could trigger the maximum punishment.
Exactly.
It really hammers home the idea that your data isn't just, digital exhaust. It's your property. To summarize our exploration today, these rules on transparency and accountability are just there to ensure you stay the owner of your identity.
Yeah, you hold the cards now.
So here's a provocative thought to leave you with. Since the law literally grants you the right to data portability, have you ever considered if your data is currently just locked in an ecosystem simply because you haven't exercised your right to move it? Like, what would you move today if you took your data and just left?
We live in a world where pretty much every click, every sign up, every single online purchase shares a little piece of you. It makes you wonder, right? Who's actually looking out for your personal information? Well, today we're going to unpack the power that you, as a Filipino citizen, have over your own data. And it's all thanks to one really important law. I mean, really think about it for a second. Your name, your address, your phone number, you type it all in, you hit submit, and boom, it's just gone, out into the digital universe. But where does it actually end up? And who gets to decide what happens to it next? This is a question that, honestly, affects every single one of us. But here's the good news. What happens to your data isn't some big unsolvable mystery. There's a landmark law passed back in 2012 that was specifically designed to shed some light on this whole process, and, more importantly, put the control right back where it belongs, with you. And we are talking about Republic Act number 10173, but you probably know it better as the Data Privacy Act of 2012. The best way to think about this law? It's like a digital shield, a protective force field for the personal info of every Filipino, whether that data is being handled by a government office or a private company. But this isn't just some dry technical rulebook. No, this law goes way deeper. Right there in Section 2, it says its whole purpose is to protect a fundamental human right. That's huge. It means this whole thing is built on the idea that your privacy isn't just a preference, it's essential. Okay, so to really get how this all works, we need to know who's on the field. The law basically sets up three main roles in this whole data ecosystem. And to make it super simple, let's think of it like this. There's the owner of the data, the custodian who's holding it, and the referee who makes sure everyone's playing by the rules. First up, and without a doubt, the most important player is you. In the eyes of the law, you're called the data subject. It's just a legal-sounding term for the person whose information is being collected and used. And here's the key takeaway. It's your data. You own it. Period. So what about the company, the app, or the government agency that's asking for your info? They're called the Personal Information Controller. Think of them as the custodian. You've entrusted them with your property, your data, and now they have a serious legal responsibility to take care of it and use it the right way. And who's there to make sure these custodians are actually playing fair? That's where the National Privacy Commission, or the NPC, comes in. They are the independent referee in this game. It's their job to enforce the law, look into complaints, and make sure everyone is respecting your right to privacy. So now that we know the players, let's get to the best part. This law isn't just about setting rules for companies. It's really a charter of rights for you. It gives you specific, real-world powers over your own information. Think of this as your personal data privacy toolkit. You have the right to be told what they're collecting. You have the right to actually see that data. If it's wrong, you have the right to fix it. You can even demand they delete it. If they mess up and you're harmed, you have a right to damages. And you even have the right to take your data and move it somewhere else. These 6 rights, they are the absolute core of your power. All right, so organizations are the custodians of your data, but that doesn't mean they can just do whatever they want with it. Not even close. The Data Privacy Act lays down some very clear, very specific rules of the game that they absolutely must follow. Now, one of the biggest rules to understand is that not all data is created equal. The law makes a really important distinction here. You've got personal information, which is stuff like your name and address, but then you have sensitive personal information, things like your health records, your race or religion, or even government IDs. That stuff gets an even higher, more serious level of protection. And on top of that, any organization that handles your data has to live by 3 core principles. First, transparency. They have to be upfront and honest with you. Second, legitimate purpose. They can't just collect your data for the fun of it. They need a specific, valid reason. And finally, proportionality. They can only take the data they truly need for that reason and not a single bit more. So, what happens when these rules get broken? Well, this isn't just some friendly recommendation. The Data Privacy Act has some serious teeth, and there are severe consequences for anyone who misuses your information. Let me just put a number on that for you. $4 million. Pesos. Yeah, that's the maximum fine for messing with your sensitive personal information without authorization. That's a number that definitely gets your attention, and it's supposed to. And you know what? It is not just about the money. Things like getting rid of your data improperly or trying to hide a security breach can lead to massive fines and actual prison time. The message from the law is crystal clear. Protecting people's data is not optional. It is a non-negotiable responsibility. So here's the bottom line. Your data isn't just a bunch of ones and zeros floating around in the cloud. It's a part of you. And here in the Philippines, it has legally protected rights. Now that you know what those rights are, the power is officially in your hands. The real question is, what are you going to do with it?
Okay, so let's unpack this. We spend an inordinate amount of time curating our physical selves, right?
Oh, absolutely.
Like, we worry about what we wear before we leave the house. We make sure to lock our doors at night. We shred our bank statements. Well, I mean, some of us do.
Most of us probably should do it more often.
Right, exactly. But there is this whole second version of you out there, a version that exists entirely on servers, floating around in cloud storage, or, stuffed into dusty filing cabinets in the basements of government offices.
Yeah, what we call the digital self.
The digital self, exactly. And for the longest time, it really felt like that version of us was just living out in the Wild West.
It really was.
Companies could basically just take it, trade it, lose it, or sell it to the highest bidder. And all you could do is click I agree on some 50-page terms of service document and just cross your fingers.
Yeah, nobody reads those.
Nobody. But today we are doing a deep dive into the rule book that, at least in theory, tames that Wild West. We are looking at Republic Act number 1773.
Which is much better known as the Data Privacy Act of 2012. And I'm really glad you used the word rulebook there, because that is exactly what this is.
Right.
It is not just a polite suggestion. It's not a set of loose guidelines. It is a strict liability statute. And it fundamentally changes the relationship between you, the person who actually owns the face, and the company that owns the photograph of your face.
We have a massive stack of sources for this deep dive today, primarily the full text of the Act itself, along with some of the implementing rules and regulations. Our mission here is to decode all this heavy legal jargon into something you can actually use.
Because it really is dense.
It is. But I want to be super clear right up front. This matters to everyone listening.
Yeah.
This law defines your actual rights over your own identity.
And it creates this really fascinating tension right off the bat, if you read closely. If you look at Section 2, which is the Declaration of Policy, the state explicitly says it has a duty to protect the fundamental human right of privacy.
That's the shield.
Exactly, the shield. But in the very same sentence, I mean, practically in the same breath, it says it also has to ensure the free flow of information to promote innovation and growth.
And that right there is the central conflict of the modern world, isn't it?
It really is.
Because we want absolute privacy, but at the same time, we also want our credit cards to work instantly when we travel to a foreign country.
Right.
We want Amazon to just automatically know what books we might want to read next. And we definitely want the government to process our driver's licenses faster than a snail's pace.
Precisely. Because if you have zero data flow, the economy just stops. But if you have total data flow, privacy is completely dead. The Data Privacy Act is essentially the referee in that match. It establishes the boundaries.
And the hook for you listening right now, the reason you really cannot tune this out, is that the penalties for crossing those boundaries are incredibly severe.
We're talking about actual jail time.
Actual prison.
Yes. Not just for, malicious hackers in a basement or international identity thieves, but potentially for an HR manager who just throws a printed resume into the wrong trash can.
Or a government official who gets a little lazy with an unencrypted USB drive.
Exactly.
So let's get right into the mechanics of this. We are going to break this deep dive down into the who, the what, the how, and the or else. Let's start with the cast of characters. Who are the actual players on this board?
Well, the most important character is you. The law calls you the data subject. Section 3 defined the data subject very simply as the individual whose personal information is processed.
So if my data is in a system, literally any system, I am the subject.
That's right.
Okay, so if I'm the subject, who is the antagonist? Or, well, I guess just the other party in this relationship.
The law refers to them as the personal information controller, or PIC. This is the person or the organization who controls the collection, the holding, the processing, or the use of personal information.
The people.
Right. And the real key word to remember there is control. They are the ones making the executive decisions. They decide why they need your data in the first place and exactly how they're going to use it.
Okay, this is where I want to just pause for a second and clarify something because I can already hear people listening starting to panic.
Oh, sure.
Let's say I have a list of my friends' birthdays and their phone number saved on my phone, maybe 100 people. Am I suddenly a personal information controller? Do I need to, go hire a lawyer and appoint a data protection officer for my iPhone contacts?
That is a fantastic question. And honestly, it's one that comes up constantly when the people first read this. But no, Section 3 actually gives you a specific pass.
Oh, thank goodness.
Yeah, there is a very crucial distinction in the text of the law. The term personal information controller explicitly excludes an individual who collects or uses personal information in connection with their personal, family, or household affairs.
Okay, so my holiday card list is safe.
Safe.
My wedding invite list.
Safe. Yes. If you are just keeping track of your cousins for a summer family reunion, you are not a controller. The law isn't interested in regulating your private social life.
But where exactly does that line get crossed?
The line is crossed when the intent or the purpose shifts from being strictly personal to commercial or professional.
Give me an example.
Sure. Let's take that exact same list of cousins.
Yeah.
If you suddenly decide to use those phone numbers to start cold calling them to sell insurance policies or, market a new multi-level marketing scheme to them,
Oh, right.
now your intent has changed. Now you are acting as a controller and you absolutely fall under the jurisdiction of the law.
Got it. So it's the intent that defines the role. That makes sense. Now, there is a third character in this cast, right? The processor.
Right. The personal information processor, or PIP. You can think of this entity as the subcontractor. It's the person or company to whom the actual processing work is outsourced.
Let's ground that with a real-world example.
Okay, imagine a major bank. The bank is the controller. They hold your account details. They decide they need your credit history to give you a loan. But let's say the bank doesn't want to build its own massive server farm. So they hire a third-party cloud storage company to actually host the servers where all that data physically lives.
Okay.
Or, another example, they hire a completely separate payroll company just to handle processing their own employees' paychecks every 2 weeks. That cloud company or that payroll company, they are the processors.
So they don't own the data. They are just handling it on behalf of the bank.
Exactly.
Which brings up a really big question. If that cloud company gets hacked, or if the payroll company accidentally leaks the employee data onto the public internet, who gets in trouble? Who is responsible? The bank or the subcontractor?
This is a huge point in the law.
Oh.
The controller, the bank, in our example, is still the captain of the ship.
So they can't just blame the vendor.
They absolutely cannot just pass the buck and say, oh, well, it was the cloud vendor's fault, go sue them. Section 21 of the Act makes it incredibly clear. The controller is fully responsible for personal information under its control or custody, and that specifically includes information that has been transferred to a third party for processing.
Wow, that is massive. It means you really can't outsource your liability. You can outsource the technical work, but if the ship goes down, the captain goes down with it.
Precisely. And what this does practically is it forces companies to vet their vendors very, very carefully. You can't just go with the cheapest cloud provider if they have terrible security, because it's your neck on the line.
Now, we are mostly talking about the internet here, which historically doesn't really respect national borders.
Right.
But Section 6 of our source text describes this concept of extraterritorial application. Usually, if I look at Philippine laws, they stop at the Philippine border. Like if I'm driving in California, I don't have to worry about Manila traffic regulations.
True. But data is fundamentally different. Section 6 is what lawyers call a long-arm statute. It states that this act applies to an act done or practice engaged in outside of the Philippines if certain conditions are met.
Wait, really? So a giant tech conglomerate in Silicon Valley or a massive server farm in Singapore could actually be held liable under this Philippine law?
Yes, absolutely. The act applies if the person whose data is being processed is a Philippine citizen or a resident.
Regardless of where the company is?
Yes. And it also applies if the entity has some kind of tangible link to the Philippines. That could mean they entered into a contract in the Philippines, or they have a branch office there, or even if their central management is located in the country.
So let's say a global social media platform has a physical sales office in Taguig, but all their actual servers are sitting in, say, Ireland. If they mishandle the data of a Filipino user,
They are on the hook. They have to play by these rules. The whole point of Section 6 is to prevent companies from playing a corporate shell game where they say, oh, sure, we make billions operating in the Philippines, but technically the data lives on a server in a tax haven, so your laws can't touch us.
Right.
The law steps in and says, no, if you deal with Filipinos, you deal with Philippine privacy law.
That is genuinely empowering. It
Yeah.
means your digital rights travel with your citizenship.
They do.
But let's look at the flip side of this for a moment. Is anyone exempt from this? Because blanket privacy sounds great, but does anyone get a free pass for a good reason?
There are exemptions, yes, specifically laid out in Section 4. And these are really critical for maintaining a functioning, open, democratic society. The biggest and most obvious one is what we can call the journalist shield.
That would be Section 4.
Right. Information processed strictly for journalistic, artistic, or literary purposes is exempt. And Section 5 explicitly reinforces this to protect the freedom of the press and to protect the confidentiality of journalistic sources.
And that makes total sense. Because you wouldn't want, say, a highly corrupt public official to be able to use the Data Privacy Act to sue a newspaper just for publishing their name in an investigative report.
Exactly. That would be weaponizing a privacy law to destroy public transparency. If you are a public figure involved in a matter of legitimate public concern, you cannot hide behind this law to silence the press.
Are there other exemptions?
Yes, there are exemptions for government officials specifically regarding their public functions.
What does that mean exactly?
It means you can't be a public official and claim your government salary grade is private information. That is a matter of public record.
Got it.
And crucially, there's an exemption for information that is necessary for banks and financial institutions to comply with anti-money laundering laws, the AMLA.
So you can't walk into a bank with a duffel bag full of cash, and when they ask where it came from, you say, I refuse to tell you because of my data privacy rights.
Right. You absolutely cannot do that. Privacy cannot be used as a shield to facilitate financial crimes.
Okay, so we know the cast of characters now. Let's move to the script itself, the actual data. Reading through the law, it seems to split data into two very distinct tiers. There's the standard stuff, and then there's the really radioactive stuff.
Radioactive is a very good way to put it. So first, you have standard personal information, which is defined in Section 3G. Basically, this is any information from which the identity of an individual is apparent or can be reasonably and directly ascertained.
It's that phrase, reasonably and directly ascertained, that feels a little broad to me, so it's not just my first and last name.
Far from it. It encompasses what data scientists call the mosaic effect.
The mosaic effect?
Yes. Imagine I have a data set that has been completely stripped of names. No John Doe, no Jane Smith.
Okay.
But the data set does contain your highly specific job title, the exact physical location of your office building, your exact age, and the specific university you graduated from in a specific year.
Well, there's probably only one person in the entire world who fits that exact combination of traits.
Exactly. Even without seeing the name. By combining those data points, those tiles in the mosaic, I've reasonably and directly ascertained that it is you. Therefore, that entire data set is protected personal information.
Wow. But then we have the second tier, right? Section 3. Sensitive personal information.
Yes. This is the data that can fundamentally ruin your life or your livelihood if it gets out. The law treats this category completely differently because the potential risk of harm to the individual is exponentially higher.
So what exactly makes the list for sensitive info?
It includes things like your race, your ethnic origin, your marital status, your age, your color, and your religious, philosophical, or political affiliations.
Wait, hold on. Political affiliations. So if there is a list of registered party members or a list of campaign donors, that is legally considered sensitive personal information.
Yes, it is. And there's a profound historical reason for that. In many parts of the world, and certainly throughout history, simply knowing someone's political affiliation could put them in actual physical danger.
That makes sense.
The law recognizes that vulnerability. If your political leanings are leaked, you could face discrimination, loss of employment, or worse.
What else is on the sensitive list?
It includes your health records, your education records, your genetic life, and your sexual life.
So the deeply, deeply personal stuff.
Right. But it gets even more serious. It also includes any proceeding for any offense committed or even just alleged to have been committed.
So criminal records.
Criminal records, yes. But also just the mere fact that you are currently on trial or under investigation, even if you're entirely innocent. And finally, it covers government-issued IDs, things like your social security number, your tax returns, your driver's licenses.
Basically, the master keys to your identity kingdom.
Exactly.
Now, how does the law actually treat this sensitive tier differently from, say, just my name and a generic email address?
Section 13 establishes what we call the prohibition principle. The general default rule for sensitive personal information is that processing it is completely prohibited.
Wait, so the default answer is just no?
The default is absolutely no. For standard personal info, the law is generally permissive as long as you follow the basic rules of consent and security. But for sensitive info, the door is heavily locked and bolted by default. You have to find a very specific key, a legal exception, to even be allowed to open it.
Okay, so what are the keys? Because obviously hospitals process health data every single day and banks process tax returns for mortgages. How do they get anything done?
The biggest and most common key is consent. But it is not just casual consent. It has to be highly specific to the purpose.
So no hidden clauses.
Right. You can't just bury a blanket, I agree to let you do whatever you want with my data clause on page 40 of the fine print. The data subject must agree specifically to the processing of their sensitive information for a clearly stated, specific reason.
What happens if I physically can't give consent? Let's say I'm in an accident.
The law accounts for that. There is an exception for protecting the life and health of the data subject. If you are wheeled into an emergency room completely unconscious, the doctors don't need to stand around waiting for you to wake up and sign a privacy waiver before they can check your medical history or process your blood type.
Well, that is certainly reassuring.
Yes. The law prioritizes human life over data privacy in an emergency.
Makes sense.
There are also a few other exceptions. For instance, for lawful defense in a court proceeding. If you are being sued, you are allowed to use sensitive data to defend yourself. And as we kind of touched on earlier, existing laws like tax laws or banking regulations can override the prohibition.
So if the Bureau of Internal Revenue requires my tax return, I can't just quote Section 13 at them and say no.
Correct. The state still has to function.
So to summarize the architecture here, standard data is generally okay to process as long as you play by the rules. But sensitive data is entirely forbidden unless you have a very specific, legally defined reason.
Exactly. You've got it.
All right, let's move into Section 3 of our outline. I think this is arguably the most practical and important part for everyone listening today. This is the toolkit. These are the actual specific rights you have as a data subject.
And Section 16, which outlines these rights, is often referred to as the Empowerment Clause. It really is the Bill of Rights for the digital citizen. And honestly, it is so vital to know these because a lot of companies basically bank on the fact that you do not know them.
Let's walk through them one by one. First up is the right to be informed.
This is the foundational right. You absolutely must know the scope, the purpose, and the recipients of your data before your data ever enters their system.
This is why we are constantly bombarded with those pop-up privacy notices on every website we visit.
Exactly. And I know we all just blindly click except to get them out of the way, but legally, that notice has to be there, and it has to be written clearly. They are legally required to tell you exactly what data they are taking, exactly why they are taking it, and this is the part companies hate, who they are giving it to.
Oh, the third-party sharing.
Right. If a privacy policy just vaguely says, we share your data with trusted partners, that is very often too vague to be compliant. You have the right to know specifically who those partners are.
Which leads perfectly into the next tool in the kit, the right to access.
Right. This goes much deeper than just being informed generally. You have the right to demand to see the actual physical contents of your personal information that they hold.
Just ask to see my file.
Yes, you can ask for their sources, like where did you buy this information about me? You can ask for the names of all the recipients they sent it to, and you can ask for the explicit reasons why they disclosed it.
So let's play out a scenario here. Let's say I apply for a home loan, I get rejected. The bank just sends an automated email that says, rejected due to internal scoring metrics. I can use my right to access to go back to them and say, no, show me the exact data you used to make that decision.
Yes, you absolutely can. You can demand to see the exact information that led to that specific credit score.
And what if they show me the file and I find out that they have the completely wrong salary listed for me? Or what if they have my file confused with a different person who has the same name and defaulted on a loan 5 years ago?
Then you immediately use the next tool, the right to rectification.
Okay.
You have the legal right to dispute those errors. And the controller doesn't just get to think about it. They must correct it immediately.
That's great.
But here is the real kicker, and this is where the law gets incredibly smart. The controller also has to inform any of the recipients of that data about the error.
Oh, wow. So if the bank took that bad credit score and they sent it off to a national credit bureau before I caught the mistake, and I forced the bank to fix it in their system, the bank actually has to go track down the credit bureau and tell them, hey, we messed up, you need to update this guy's score too.
Yes. They cannot just quietly fix the typo on their local server and leave your bad data floating around out there in the broader financial ecosystem, destroying your credit. The burden is on them to chase it down and correct the record everywhere they sent it.
That is incredibly powerful. Okay, what about the right to erasure or blocking? This is often called the right to be forgotten, right?
It is. Now, it is not an absolute blanket right to be forgotten like they have in some parts of Europe, but it is very close. You have the right to suspend, withdraw, or order the complete destruction of your information if it is incomplete, outdated, unlawfully obtained, or, and this is by far the most useful clause, if it is no longer necessary for the purposes for which it was originally collected.
Let me make sure I understand that. So if I signed up for a local gym membership, say 5 years ago, I canceled it 4 years ago, but I find out they are still holding on to my credit card details and my home address just in case I ever come back, I can legally force them to delete it.
Yes, absolutely. The original purpose, which was charging you monthly for access to the gym, is gone. Therefore, their legal justification for holding the data is gone. They cannot act as data hoarders. You tell them to delete it, and they must delete it.
And what if they don't? Or what if they already messed up and leaked my data or used it in a way that caused me harm?
Then you invoke the right to damages. The law explicitly states you can be indemnified for any damages sustained due to inaccurate, incomplete, outdated, false, unlawfully obtained, or unauthorized use of your personal information.
So I can sue them.
This is the legal foundation that allows for class action lawsuits after a major data breach, or for individual civil claims for financial compensation if an error cost you a job or a loan.
Now, there are two other rights in this section that feel very modern, very forward-thinking. Section 18 covers data portability.
This is a brilliant provision. It states that if your data is processed by electronic means, you have the right to obtain a copy of that data in a structured and commonly used format that allows you to actually use it somewhere else.
It sounds a lot like what happened with mobile phone numbers. 10 or 15 years ago, if you wanted to switch telecommunications providers, you had to give up your phone number. It essentially locked you into bad service because you didn't want to text everyone a new number. But now, by law, you can just port the number over. This law is saying you should be able to do that exact same thing with your digital data.
That is the perfect analogy. If you have built up 10 years of complex transaction history with one specific bank, or you have a massive curated social graph on a particular social media platform, you should theoretically be able to demand that data in a usable, machine-readable format and just move it directly to a competitor.
It completely undermines corporate lock-in.
Exactly. It's a fundamental assertion by the state that you own your data. The platform does not own you.
And the last one in this right section is section 17, transmissibility. I have to admit, reading this one, it sounds a little bit morbid.
It does.
Yeah.
But it deals with a very real modern problem, the digital afterlife. Your data rights do not simply vanish the moment you die. The law says that the lawful heirs and assigns of the data subject can invoke all of these rights after the data subject's death, or if they become legally incapacitated.
Which solves a massive headache for grieving families. We've all heard those horrible stories of families who are completely locked out of the email accounts of deceased relatives, so they can't close out bank accounts, they can't stop recurring billing, or they can't retrieve family photos.
Or, conversely, a family being completely unable to shut down a deceased loved one's Facebook page that is suddenly being targeted by internet trolls. Section 17 clarifies that the legal heirs step directly into the shoes of the data subject. Your digital rights are essentially treated as part of your legal estate.
Okay, so we have all these amazing rights, but rights on a piece of paper are really only as good as the actual security systems protecting them in the real world. So let's move to section 4 of our outline, which covers the rules of engagement, security, and accountability. Section 20 of the Act lays out what is known as the CIA of data security. And just to be clear for the listeners, no, we are not talking about the American Spy Agency.
No. In the world of information security, CIA stands for confidentiality, integrity, and availability. The law legally mandates that every controller must implement measures to ensure these 3 specific pillars are maintained. And what's really interesting is that the Act actually breaks down the categories of measures required: organizational, physical, and technical.
I think people naturally just fixate entirely on the technical side. When we hear data security, we just think, oh, I have a good firewall and I use a strong password, so I'm compliant.
Exactly, that's the instinct. But Section 20 explicitly says that technology alone is not enough. You need organizational measures first.
What does that look like?
This means the actual structure of your company. Having a written privacy policy that employees have to read, appointing a dedicated data protection officer, and most importantly, actually training your staff. Because you can have the most expensive military-grade encryption software in the world, but if your front desk employee doesn't know that they shouldn't email the entire unencrypted customer database to their personal Gmail account so they can work from home over the weekend, your technical security has completely failed.
Right. The human element is always the weakest link. And then the law mandates physical measures.
This is the one that gets chronically ignored in our hyper-digital age. Physical security means actual metal locks on the door to the server room.
Right.
It means consciously positioning your employees' computer monitors so that people walking through the lobby can't just read sensitive client data over their shoulders. It means having a functional paper shredder in the office.
I was actually in a medical clinic just recently, and the receptionist there left a massive stack of patient intake forms with names, addresses, symptoms, just sitting right on the front counter while she walked away to take her lunch break. Literally anyone in the waiting room could have just casually flipped through them.
And see, that is a direct, actionable violation of the physical security measures required under RAO 10173. It doesn't require a sophisticated Russian hacker to steal data. Sometimes it just requires a nosy person in a waiting room and a careless employee.
Now, what happens when all those walls, technical and physical, are actually breached? Because we see the headlines every week. The dreaded data breach. Section 20 talks about the breach notification rule.
This is what I call the ticking clock provision. The law is realistic. It recognizes that breaches are going to happen. It's almost mathematically inevitable for large organizations. So the crime isn't necessarily being the victim of a hack. The crime is what you choose to do after you find out.
So what is the legal trigger? When do you have to sound the alarm?
The law says if sensitive personal information is breached, and there is a reasonable belief that this breach is likely to give rise to a real risk of serious harm to the data subject, then the controller absolutely must notify the National Privacy Commission, the NPC, and they must notify the affected person.
They cannot just quietly sweep it under the rug and hope nobody notices.
Absolutely not. And there's a lot of nuance here regarding timing. The law states that notification can be delayed only to the extent necessary to determine the scope of the breach or to restore the reasonable integrity of the data system.
So basically, you can take a quick moment to figure out what was stolen and to plug the digital hole so the hackers don't just immediately get back in while you're writing the email.
Right. That makes operational sense. But
Yep.
you absolutely cannot delay notification just because you are terrified of the bad PR or because you're trying to wait until a Friday afternoon on a holiday weekend to bury the news cycle.
And who internally is on the hook for making sure this happens? Section 21 covers accountability.
This is the buck stops here clause. As we mentioned when talking about processors, the controller organization is ultimately responsible. But the law goes one step further. The organization must formally designate a specific named individual who is personally accountable for the organization's compliance.
That would be the data protection officer, the DPO.
Yes, every organization needs a face to go with the name. You need someone you can actually call. And the law explicitly says that the identity of this DPO must be made known to any data subject upon request. You have the fundamental right to know exactly who is guarding the vault.
Okay, so up until now, we've really been talking about private companies, banks, gyms, tech platforms, but the government itself holds a genuinely massive amount of our data.
Most sensitive data, usually.
Exactly. And let's be brutally honest here. Government IT security doesn't exactly have a sterling world-class reputation in most places. Does RA 10173 apply to the state as strictly as it applies to private business?
It absolutely does. And honestly, this is one of the most interesting parts of the entire source text. If we look at Section 5 of our outline, it highlights that the state is actually held to a notably higher standard than the private sector.
Really? A higher standard?
Yes. Section 22 explicitly states that sensitive personal info maintained in government custody must be secured with the most appropriate standard recognized by the information and communications technology industry.
The most appropriate standard. That sounds like a deliberately high bar to clear.
It is. It is essentially the law saying that good enough or budget-friendly is not an acceptable excuse for the government when handling citizen data. But then you get to Section 23, which is truly fascinating. It introduces the 1,000 records rule.
I read this part and it honestly sounds like a protocol out of a spy movie.
It is extremely strict. It places highly specific procedural limits on accessing sensitive government data offsite. So let's play out a scenario. Let's say a government employee wants to take a data set home on their laptop to work on it over the weekend, or maybe they just want to access the government server from a coffee shop Wi-Fi network.
Which, let's face it, happens all the time in the modern era of remote work.
Right. But under this law, if that remote access involves more than 1,000 individual records, the head of the agency must approve that request personally.
Wait, the actual head of the agency, like we are talking about the cabinet secretary or the director general, they have to personally review and sign off on some mid-level employee's weekend IT request?
Yes, legally they do.
Yeah.
The law intentionally forces the responsibility for mass data access to the very, very top of the organizational chart. And they have a strict deadline to make a decision. They must either approve or disapprove the request within 2 business days.
And if they're busy and don't act on it?
If they don't act within 2 days, the request is automatically disapproved by default.
So the default is always no.
Always. And even if the agency head does review it and says yes, the legal limit is access to not more than 1,000 records at any one time. An employee cannot just casually download the entire national database of registered voters or the entire registry of taxpayers onto an external hard drive.
That is clearly designed specifically to prevent those massive, catastrophic leaks we hear about in the news where someone leaves a flash drive containing 50 million citizen records in the back of a taxi.
Exactly. It creates a deliberate operational bottleneck. If a bad actor internally wants to steal the whole national database, they have to do it 1,000 records at a time, and they have to get the agency head's explicit signature on every single batch. It makes mass data exfiltration operationally exhausting and highly visible.
And on top of that, the law says the technology used for this offsite access must use the most secure encryption standard recognized by the Commission.
Right, so absolutely no unencrypted USB thumb drives allowed. No sending files via personal unencrypted email.
And Section 24 adds that this strict framework applies to government contractors, too.
That's a vital loophole to close. If you are a private tech vendor building a software system for the government, and that system handles 1,000 or more records, you have to formally register your system and follow these exact same strict rules. You don't get a pass just because you're technically a private company doing the work.
Okay, so we have laid out the rules, we know the players, we know the security standards. But who is actually enforcing this? Who is the referee blowing the whistle when someone breaks a rule?
That brings us to Section 6 of our deep dive, the watchdog. The Act specifically created the National Privacy Commission, or the NPC.
Where exactly do they sit within the government bureaucracy?
They are an independent body, officially attached to the Department of Information and Communications Technology, the DICT.
Why does their independence matter so much?
Their independence is crucial because they have a dual mandate. They have to regulate and police the private sector, the big banks, the tech companies, but they also have to police the very government agencies they sit alongside. If they weren't independent, they could never effectively sanction another government department.
So what can the NPC actually do? Are they just a toothless advisory board that writes angry letters, or do they have actual bite?
Oh, they have serious bite. Section 7 outlines their core functions. First, they have investigative powers. They can receive complaints directly from citizens and institute official investigations. They don't have to wait for a lawsuit to be filed in court. They can just knock on your corporate door and demand answers.
And if they look around and find something seriously wrong,
then they use their punitive powers. Most notably, they have the power to issue cease and desist orders.
a cease and desist, so they can legally tell a company, stop processing data right now, today.
Yes. If the NPC determines that the processing of personal data is detrimental to national security or to the public interest, they can outright ban the processing. Just think about what that practically means for a modern tech company, or an e-commerce platform, or a bank. If you are legally barred from processing data, you're effectively out of business overnight.
That is the nuclear option.
It really is.
Yeah.
Beyond that, they also have an educational role, publishing guides and clarifying the law for businesses. And they have a really important international role.
Because data crosses borders constantly.
Exactly. They negotiate cross-border enforcement agreements. Because if a company in Singapore is violating the rights of a citizen in Manila, our regulator needs to be able to pick up the phone and coordinate with regulators in Singapore or Europe or the United States.
Now, I noticed Section 8 notes that the commission itself is legally bound to strict confidentiality, which makes sense because during an investigation, they're going to see a lot of a company's dirty laundry.
Correct. They are examining the breach data. They are looking at sensitive internal security flaws. They are legally barred from becoming the source of a secondary leak.
All right, this brings us to the part I teased right in the intro, the or else. Section 7 of our outline, crime and punishment. We're talking about severe prison time and massive fines here. Let's look at the actual severity of these penalties.
The penalties outlined in Chapter 8 are incredibly significant because they almost universally combine both imprisonment and steep financial fines. And the law carefully distinguishes between violations involving standard personal information versus violations involving sensitive personal information.
Let's start with the most basic one, unauthorized processing under Section 25.
If you process standard personal information without the subject's consent or without proper legal authority, the penalty is 1 to 3 years in prison and a fine of up to 2 million pesos.
And if it happens to be sensitive information, like, say, someone's private health records or political affiliation,
then the penalty jumps significantly. It goes to 3 to 6 years in prison and a fine of up to 4 million pesos.
6 years. I mean, that is a significant life-altering chunk of your life. Now, those are intentional acts. What if you didn't mean to do it? What if you weren't trying to steal data? You were just, sloppy.
This is where the law gets genuinely scary for the incompetent. Section 26 covers accessing due to negligence. You do not have to be malicious to go to prison. Yes. If you provided access to data simply due to negligence, meaning you left the master password on a sticky note on your monitor, or you left the cloud database configured to be publicly open to the internet without a password, you can still go to jail.
What is the penalty for being that negligent?
If it involves sensitive info, the negligence penalty is 3 to 6 years in prison.
Wait, hold on. Let me make sure I'm reading that right. Being merely negligent with sensitive data carries the exact same maximum prison time as intentionally and maliciously processing it.
The maximum is exactly the same, yes. The law is effectively making a philosophical statement here. Incompetence is not a valid legal excuse when it comes to protecting people's private lives. If you're going to take on the responsibility of holding the data, you have a strict legal duty to not be negligent with it.
That is a massive wake-up call for every IT department. Now let's talk about the one that blew my mind, the dumpster diving clause. Section 27. Excellent. Improper disposal.
This is the one that always surprises people when I explain it. Improper disposal. If you knowingly or negligently dispose of personal information in an area that is accessible to the public, like a standard trash container, you can face prison time.
So let's paint a very mundane, everyday picture here. An HR manager is reviewing candidates. She prints out a physical copy of a resume. It has a person's full name, their home address, their phone number, maybe a photo. She reads it, decides not to hire the person, crumples it up, and just throws it in the regular open office bin under her desk. That evening, the cleaning crew empties that bin into the large black bags and puts them on the street for pickup.
That entire sequence of events is a crime under this act.
It's just for throwing a piece of paper away.
Yes. It carries a penalty of 6 months to 2 years in prison for standard info, and 1 to 3 years if that paper contains sensitive info. The law explicitly requires you to ensure the data is completely unreadable upon disposal.
So you really have to shred it.
You must shred it, burn it, or pulp it. You cannot just throw it away.
Note to self, immediately buy a cross-cut shredder for the home office. Because honestly, this seems like the absolute easiest way for a regular, well-meaning person to accidentally commit a felony under this act.
It absolutely is. It is the government's way of enforcing a mandatory clean desk and secure destruction policy across the entire economy.
What about acts with actual malicious intent? Like intentionally smearing someone online?
Section 31 covers malicious disclosure. If you disclose false or unwarranted information with actual malice or in bad faith, the penalty is 1.5 to 5 years in prison. This is specifically designed to protect citizens against people weaponizing data to destroy someone's personal or professional reputation.
And we also mentioned the crime of concealing a breach earlier.
Right. Section 30, concealment of security breaches. If you are a controller and you know for a fact that your systems have been hacked, and you know you are legally obligated to report it to the MPC, but you actively choose to hide it to save face, you can face up to 5 years in prison just for the cover-up. The cover-up is treated as a severe crime in and of itself.
Finally, there is a penalty multiplier in the law, right?
Yes. Section 35. This is the large-scale modifier. And it is incredibly important. If the violation harms, affects, or involves at least 100 persons, the judge is required to impose the maximum allowable penalty.
Wait, 100 persons, that is a tiny number in the digital world. A small local bakery's Excel spreadsheet of loyalty program customers probably has way more than 100 names.
Exactly. A neighborhood newsletter mailing list has more than 100 names. This incredibly low threshold means that practically almost any corporate data breach is going to instantly trigger the large-scale modifier. Even just CCing the wrong group of 100 clients on an email instead of BCCing them could theoretically trigger it.
So if that modifier is triggered, the judge essentially loses their discretion. They can't be lenient.
They cannot be lenient on the sentencing term. They have to impose the maximum penalty bracket. It ensures that mass data breaches, even relatively small mass breaches, are punished with the absolute full weight of the law.
Okay, so let's try to summarize everything we've learned today. This deep dive into Republic Act 10173 really shows us that this law fundamentally shifts the power dynamic. It moves power away from the massive institutions and gives it back to the individual citizen.
It does. And it fundamentally changes the economic nature of data itself. For years, the mantra in Silicon Valley and in global business was, data is the new oil.
Right.
The idea was to just accumulate as much of it as possible, even if you didn't know what to do with it yet, because it inherently had value.
But reading the strict liabilities in RA 1173, it actually suggests that data is much more like toxic waste. Or maybe asbestos.
Asbestos is a great analogy. It's highly useful in certain contexts, but if you choose to hold it inside your building, you have a massive legal obligation to secure it. You have to constantly monitor it to make sure it isn't leaking, and eventually you have to pay a lot of money to dispose of it properly and safely.
Because if you just hold on to it when you don't actually need it, it's just a massive, unnecessary legal liability waiting to explode.
Exactly. The entire framework of the law incentivizes data minimalism. Collect only exactly what you need to do the job, and the very second you are done with it, delete it.
So for you, the listener, the ultimate takeaway here is about personal relevance. The next time you are standing at a doctor's office, filling out a clipboard, or you're downloading and signing up for a new app on your phone, or even if you're just dealing with your own company's HR files, remember that you have concrete, legally enforceable rights. You are a data subject. You can look at them and ask, who is your data protection officer? You can say, I want to see exactly what records you hold on me.
And conversely, for those of you who actually handle data in your daily jobs, whether you are working in HR, or you're an IT admin, or you're a salesperson just keeping a client list on your laptop, please remember Section 26. Merely being negligent is a crime. Do not be the person who ends up facing a prison sentence just because you left an unencrypted folder on the commuter train.
Or because you threw a printed resume into the wrong office bin.
Exactly. When in doubt, shred it.
Before we wrap up this deep dive, I want to leave you with one final provocative thought based on the source text we reviewed today.
Let's hear it.
So we talked about Section 23, which mandates that for any off-site government access of sensitive data, the technology used must meet the most secure encryption standard currently recognized by the Commission.
Right.
But we live in a world where technology evolves at an exponential rate. Moore's law might be slowing down a bit, but quantum computing is looming right on the horizon. What is considered the most secure standard today, like AES 256 encryption, for example, might be completely trivial for a computer to crack in 10 or 15 years. So by hard-coding a requirement for the most secure standard directly into the text of the law, does RA 10173 basically create a perpetual, impossible moving target?
That is the classic eternal problem of static, slow-moving legislation trying to regulate dynamic, hyper-fast technology.
Exactly. Are we inadvertently setting these government agencies up to fail because their procurement budgets simply can't upgrade their systems fast enough to stay legally compliant? Or, on the flip side, is this aggressive wording the only possible way to force a notoriously slow bureaucracy to actually keep up with modern threats?
It's a fascinating dilemma, because it essentially suggests the law is a living organism, completely dependent on the daily speed of academic encryption research. It forces the government to sprint on a treadmill just to stand still legally.
Does this provision effectively create a massive legal gray area where total compliance is practically impossible because the definition of most secure shifts every single time a new cybersecurity research paper is published?
It might, and that's a very uncomfortable place for a strict liability law to be.
Definitely something for you to think about the next time your computer forces you to update your password. That's it for this deep dive. Stay safe and stay secure out there.
Welcome to the debate. Today, we are opening the hood on the engine of the Philippine digital economy. We are dissecting a piece of legislation that arguably affects every single person listening to this show, usually without them even knowing it. It governs your medical records, your online shopping habits, and even how the government tracks you. We are talking about Republic Act number 10173, widely known as the Data Privacy Act of 2012.
Right. It is the law that stands between you and the companies that want to harvest your digital life. But it is also a law that some argue has thrown sand into the gears of innovation. It creates a compliance nightmare for businesses and a stumbling block for government efficiency. It is a classic case of good intentions meeting the hard reality of logistics.
Yeah. And that is exactly the tension we are here to explore today. We are looking specifically at the conflict embedded in Section 2, the Declaration of Policy. The state mandates the protection of the fundamental human right of privacy. But in the very same sentence, it insists on ensuring the free flow of information to promote innovation and growth.
And the question is, can you actually have both? Or does the fortress you build to protect privacy inevitably become a bureaucratic maze that chokes off the very free flow it claims to support?
Well, I am here to argue that RA 10173 is a necessary rights-based shield. It empowers the individual, what the law calls the data subject, against institutional overreach. It forces a pause that is absolutely vital in a digital age.
And I am taking the position that while the sentiment is noble, the execution creates excessive friction. The broad definitions, the heavy compliance burdens, and the aggressive criminalization of simple negligence threaten to paralyze both government function and private sector growth. It basically treats data like a dangerous weapon rather than a resource.
Okay, let us get into it. I want to start by framing the world before this act existed. Before 2012, data in the Philippines was essentially the Wild West. Your personal information was treated as a commodity. It was raw material to be harvested, sold, and exploited. RA 1073 fundamentally shifted the power dynamic back to the individual. You see this most clearly in how the law defines consent in Section 3B.
You're referring to the specific criteria for consent? Because usually consent is just something we scroll past.
Exactly. And the law addresses that cynicism. Before this, consent was often just a tiny checkbox you could not uncheck, or it was buried in page 40 of a contract. But Section 3B defines consent of the data subject as a freely given, specific, and informed indication of will. Those three adjectives are heavy lifters. Freely given means no coercion. You cannot force someone to give up their data just to get basic service. Specific means you cannot hide a data grab inside a generic terms of service. And informed means the user actually has to know what is happening. This forces organizations to move from a model of extraction to a model of transparency.
I agree that on paper, that sounds empowering. It sounds like the gold standard. But let us look at the practical application of the definitions. You are looking at Section 3B, but I am looking at Section 3G and 3L, which define personal information and sensitive personal information.
How so?
Well, the scope is incredibly broad. Personal information is defined as any information from which the identity of an individual is apparent or can be reasonably and directly ascertained. When you combine that with Section 4, the scope, which applies to all types of personal information, you are casting a net so wide that almost any business activity gets caught in it. If I run a small logistics startup and I have a spreadsheet of customer names and addresses, which I need to deliver packages, I am now a personal information controller subject to the full weight of this law.
But shouldn't you be? If you lose that spreadsheet or if you sell it to a scammer, you put those people at risk. That is why Chapter 4, Section 16 outlines the rights of the data subject. It gives people the right to be informed, to access their data, to object to processing, and, this is key, the right to be indemnified for damages. That financial liability forces companies to actually manage data, not just hoard it. It makes data handling a serious responsibility, not an afterthought.
Accountability is one thing, but impossibility is another. Let us look at the friction this creates for international business, which is vital for a developing economy. Section 6 deals with extraterritorial application. This act tries to regulate entities outside the Philippines if they have a link to the country.
Right, that is to prevent outsourcing violations. You cannot just move your server to Singapore or the US to escape Philippine law. That is a loophole that absolutely needed closing.
But look at the definition of a link in Section 6. It includes simply having a contract entered into in the Philippines or having a branch here. You are creating a legal quagmire where a tech company in Silicon Valley or a bank in London acts as a personal information controller and is suddenly subject to Philippine criminal law. For a global economy, that kind of friction discourages foreign investment. It tells the world if you touch Philippine data, you have to navigate our specific, complex bureaucracy or you might go to jail.
I would argue it tells the world if you want to profit from Filipinos, respect their sovereignty. Digital sovereignty is not a barrier to trade. It is a term of trade. But I want to address your point about business friction, specifically regarding this idea that the law stops innovation.
It certainly slows it down. It adds a layer of legal review to every single product launch.
I disagree. Section 11 and Section 12 bring necessary discipline, not just red tape. Section 12 lays out the criteria for lawful processing. It is not just consent. You can process data if it is for a contract, a legal obligation, or to protect the life and health of the data subject. This stops the lazy practice of collecting data just in case. Section 11D explicitly states data must be adequate and not excessive. That is the principle of minimization.
Minimization sounds great until you are trying to train an AI model or conduct large-scale market research.
Minimization actually saves companies money. Storing less junk data reduces server costs and liability. It forces businesses to be lean.
But here is where the bureaucratic maze comes in. You cited Section 12 as providing clarity. I look at Section 12F. It allows processing for legitimate interests of the controller. Now tell me, what exactly is a legitimate interest?
It is an interest that does not override the fundamental rights of the subject. It is a balancing test.
That is incredibly vague. It is a concept that invites litigation. A fintech startup might think their data mining for credit scoring is a legitimate interest because it helps unbanked people get loans. The National Privacy Commission, the NPC, might disagree and say it violates privacy. That uncertainty kills growth. Companies do not act because they are afraid of stepping on a landmine. And if the consent requirements in Section 11 are so perfect, why does Section 19 exist?
Section 19 is the non-applicability clause. It is a standard feature in privacy laws globally.
It is a massive admission of failure. Section 19 states that the strict rights regarding access and correction do not apply if the data is for scientific and statistical research. The law effectively admits that its own requirements are too burdensome for science to function. If strict consent hampers the free flow of information needed for cancer research or economic studies, isn't that proof that the core mechanism of the law is flawed?
No, it is proof that the law understands context. That is not a flaw. That is nuance. Section 19 allows for research provided that the information is held under strict confidentiality. It balances the utility of the data with the security of the subject. It proves the law is flexible, not rigid. It recognizes that research has a different social value than marketing.
I am sorry, but I just do not buy that. A law that requires a massive carve-out for basic scientific inquiry is a law that is inherently obstructing information flow. You are basically saying this law is so heavy, we have to lift it off the shoulders of the scientists so they can actually work. And it is not just research. Let us talk about government efficiency. We need to talk about Section 13 and the government's own ability to function.
Section 13 is the heart of the protection. It prohibits the processing of sensitive personal information unless specific conditions are met.
We should probably clarify for the listeners what counts as sensitive here, because it is not just your diary.
Right. Section 3T defines it. We are talking about race, health, genetic life, sexual life, and government-issued IDs like passports or tax returns. The default position of the law is that processing this data is prohibited. That is the correct default. And when it comes to the government holding this data, Section 22 and Section 23 are revolutionary. They impose security standards on the state itself.
Yeah, but Section 23 is exactly where the fortress traps the government inside. Let us look at the text regarding off-site access in Section 23B.
This regulates government employees taking data home or to the field.
Right. Now imagine we are in a crisis, a pandemic, a typhoon, a massive social aid distribution. Government employees need to access sensitive data, health records, location data, financial status, while working remotely or in the field. Section 23B requires approval from the head of the agency.
As they should. You do not want a junior clerk downloading the National Health Registry to a personal laptop at a coffee shop using public Wi-Fi. That is how leaks happen.
Well, look at the constraints. Section 23B, subsection 1 says the head of the agency has 2 business days to approve it. If they do not act, it is considered disapproved. Automatic rejection by inaction.
That forces the agency head to be diligent. It demands leadership attention.
It forces paralysis. If the head of the Department of Health is busy managing a plague, they might not sign the form in 48 hours. So the access is denied. And even if they do approve it, look at Section 23B, subsection 2. It limits the access to not more than 1,000 records at a time.
That prevents mass data exfiltration. We have seen enough leaks like the Comelec leak, where a laptop is stolen with millions of voters' data. Limiting it to 1,000 records at a time is a sensible circuit breaker.
In a vacuum, maybe, but in reality, the Department of Social Welfare distributing cash aid to 10 million people, this law forces them to process that list in batches of 1,000. That means 10,000 separate approvals, 10,000 signatures. That isn't protection. That is a bottleneck that denies services to the poor because the law prioritizes the security of the record over the utility of the government service. You are choosing data hygiene over food distribution.
It prioritizes the privacy of the citizen over the convenience of the bureaucrat. You call it paralysis, I call it due process. If the government cannot secure the data, it shouldn't be holding it. And honestly, the 1,000 limit forces them to upgrade their systems to secure cloud environments where they do not need to download records to local devices. It forces modernization. And this brings us to the enforcement mechanisms, because rules without teeth are just suggestions. Section 20 requires the Personal Information Controller to implement security measures. More importantly, Section 20F mandates notification of breaches.
The transparency requirements in Section 20 are fine, but the penalties attached to them create a culture of fear rather than a culture of security. We need to look at Chapter 8, the penalties.
The penalties are robust. Yes, they have to be.
They are draconian. Section 25 through 29 impose imprisonment. We aren't just talking about fines. We are talking about 1 to 6 years in prison. And my biggest issue is Section 26, accessing personal information due to negligence.
Negligence leads to damage. It should be punished.
But criminalizing negligence? Section 26B says accessing sensitive personal information due to negligence carries a penalty of 3 to 6 years imprisonment. Let us put a face on this. Imagine an IT administrator. Let us call him Dave. Dave is tired. He works for a hospital. He forgets to patch a server, or he leaves a file permission open by mistake. He didn't steal the data. He didn't sell it. He made a mistake. That is negligence. Under this law, Dave doesn't just get fired. Dave goes to prison for 6 years. This terrifies people out of working in data roles. It turns a mistake into a felony.
I am not convinced by that line of reasoning because it minimizes the harm. When Dave handles sensitive data, HIV status, tax returns, domestic abuse records, his negligence can destroy a person's life, identity theft, financial ruin, reputational damage. The penalty must match the potential harm to the victim, not the intent of the perpetrator. If the only penalty is a fine, large corporations will simply budget for it as a cost of doing business. They will pay the fine and keep being negligent. The threat of imprisonment in Section 26 and Section 34, where officers of a corporation are held liable, ensures that data privacy is discussed in the boardroom, not just the IT closet. It makes the CEO care about Dave's workload.
That is a compelling argument for intent or even gross negligence. But for simple negligence, it creates a perverse incentive. Have you considered the unintended consequence found in Section 30, concealment of security breaches?
Which carries a penalty of up to 5 years. It prevents cover-ups.
Where it incentivizes semantic gymnastics. Think about it. If I admit a breach, I might go to jail for negligence under Section 26. If I hide it, I go to jail under Section 30. So what happens? The legal team fights tooth and nail to define an incident as not a breach. They limit the scope of reporting. They argue technicalities. The fear of prison drives security incidents underground. We should be encouraging open reporting and remediation, like in aviation, where reporting errors is encouraged to improve safety. Instead, we are threatening jail time for every error. It creates a culture of silence.
And yet, Section 7 empowers a National Privacy Commission to issue cease and desist orders and recommend prosecution. The commission serves as a check. It is not just automatic jail time. There is an investigatory process. The NPC has been generally reasonable in its application, focusing on compliance rather than just throwing handcuffs on people.
A process handled by a body created in Section 7 that acts as investigator, prosecutor, and judge in some respects. But let us pivot to the biggest elephant in the room, the exclusions. We talked about research, but we haven't touched the financial sector.
You are referring to Section 4E.
It is the most glaring double standard in the Act. Section 4E explicitly states that nothing in this Act shall be construed to amend or repeal Republic Act No. 1405, the Secrecy of Bank Deposits Act.
That is standard legislative practice. You do not implicitly repeal major financial laws. That would destabilize the banking system.
But look at the optic. Under Section 13 and Section 25, if a hospital clerk mishandles your medical diagnosis, they face prison. Your privacy regarding your body is sacred, but your bank account, that remains shrouded in absolute secrecy, protected by RA 1405. In the Philippines, bank secrecy is notoriously strict, often criticized for aiding money laundering or tax evasion. RA 1073 claims to protect the fundamental human right of privacy, but it seems to carve out a special fortress for capital. Why is financial opacity protected under a different, stronger shield than personal dignity?
I see why you think that, but I would frame it differently. The Data Privacy Act is establishing a baseline for personal information, identity, health, relationships. The banking secrecy laws are a separate regime regarding assets. Section 4E also preserves the authority of the Central Bank and Anti-Money Laundering Council to do their jobs. If RA 10173 overrode those, it might inadvertently cripple the financial regulatory system. The Act stays in its lane. It is not trying to solve every problem in the Philippines, it is trying to solve data privacy.
Staying in its lane implies it is working efficiently. I argue it is clogging the highway. We haven't even touched on Section 12E, which allows processing for public order and safety. That is a massive loophole for the state.
Section 12E is necessary for national emergencies. You cannot have privacy laws preventing the police from stopping a crime.
But look at the imbalance. The private sector is hamstrung by the 1,000 record limit and the threat of imprisonment for negligence. Meanwhile, the state has Section 12E for public order. It feels like the law is a sieve for the powerful and a fortress against the small business. A startup cannot invoke public order to save its business model, but the state can invoke it to bypass consent.
But remember Section 23. We just discussed it. Even government agencies must strictly limit access. The Act balances the need for public order with the need to prevent a surveillance state. It is imperfect, but it is a massive improvement over the Wild West we had before 2012. It establishes that the government has to justify its access.
Is it? Or did we just swap the Wild West for a gridlocked highway? When I read Section 20 regarding security measures and then Section 26 regarding criminal negligence, I see a law that disincentivizes innovation. Small tech startups cannot afford the compliance cost or the risk of jail time. The free flow of information promised in Section 2 is being dammed up by the fear of Section 25 through 23.
The startup that cannot afford to protect its users' data implies that its business model is based on exploiting that data. If innovation requires violating human rights, then that innovation is not worth having. Section 11's requirement for transparency and legitimate purpose forces better business models, models built on trust. Privacy is not a luxury add-on. It is the foundation of digital trust.
Trust is built on performance. If I cannot get my government benefits because the agency head didn't sign the Section 23 approval within 2 days, or if medical research is stalled because of the Section 19 strictures, trust erodes. The average citizen cares about privacy, yes, but they also care about a functioning society. They care about getting their passport on time. They care about disaster relief arriving before the floodwaters recede.
The Act allows for efficiency, but not at the cost of dignity. It forces us to slow down and ask, why do I need this data, and how will I protect it? That pause is healthy. It forces the system to be deliberate rather than reckless.
That pause can be fatal in a fast-moving digital economy. It sacrifices efficiency on the altar of a bureaucracy that calls itself privacy. It treats speed as a suspect, when speed is often the source of innovation.
Well, we are nearing the end of our time. Let us summarize our positions on this landscape. You see RA 10173 as a heavy, punitive weight on the nation's information systems.
I do. It is a heavy piece of legislation. While the intent to protect data is noble, and I agree nobody wants their data stolen, the criminalization of negligence and the rigid bureaucratic hurdles prioritize a fortress mentality. The 1,000 record limit in Section 23 is the perfect example of a rule that looks good on paper but fails in the real world. The law treats data processing as a crime waiting to happen, rather than the lifeblood of a modern economy. It assumes guilt before utility.
And I view it as a necessary modernization. By creating the National Privacy Commission in Section 7 and establishing the right to data portability in Section 18, it gives individuals ownership of their digital selves. The strict penalties are the only way to ensure the policy is taken seriously in a world where data is the new oil. Without RA 1073, we are not citizens, we are just content to be monetized. It gives us a voice in how we are defined in the digital age.
It is a fundamental shift, certainly, from commodity to right or from asset to liability, depending on where you sit.
Indeed. The friction between protection and innovation is real, and it will likely require constant interpretation by the courts and the Commission.
For those listening who manage data or just generate it, which is all of us, we encourage you to read the criteria for lawful processing in Section 12 and decide for yourselves. Are you being protected or are you being processed?
Thank you for listening to The Debate.